Welcome. You're watching the Moody Lawyer. Justice served with experience and integrity.
Hello and welcome to the Moody Lawyer with attorney Josh Moody. With a rich background in law enforcement and a comprehensive legal career spanning criminal justice, personal injury, and civil matters, Josh offers a unique perspective on navigating the complexities of the legal system. I am your host, Kevin Rosenquist, and today's episode is going to be all about the complexities of multi-vehicle car wrecks. Josh, good to see you.
Hey, Kevin, good to see you. How you doing?
I'm doing great. I'm excited to pick your brain on this one. So a multi-vehicle car wreck, obviously, it's going to be a little more complicated. What are the complexities that you have to handle that compared to a single car accident?
Yeah, when I saw this as a subject to be discussed, I thought it was interesting because I kind of consider it second nature, but I don't realize that a lot of people don't. I think starting off, what kind of multi-vehicle crash are we talking about? Kind of get things out of the way. Probably your most basic common type of multi-vehicle crash is your multiple rear-ender, meaning somebody's going really fast, rear-end somebody who then rear-ends somebody else, typically 3 or 4 cars. That's typical on a freeway. Those aren't very complicated, so we're not going to spend too much time on those. Obviously, most of the time, the first vehicle suffers the full brunt of the reckless driver, the second, and so on and so forth. Those are pretty simple. But the concept remains the same. So typically on multi-vehicle crashes, the complicated ones can be where there's multiple theories of liabilities on multiple cars, or just where the velocity and the trajectory of the vehicles caused a crash. And so typically you'll have one car get hit because somebody pulls out at a stop sign or a stoplight or a driveway. They spin out and then they hit somebody or something else. Those are the multi-vehicle crashes that can be a little complicated, especially when doling out liability and doling out damages.
Yeah, with fault. I mean, that's got to be kind of a bit of a puzzle to piece together in order to figure out where the fault lies, right?
Well, a lot of times it's still one person or maybe 2 people. You try to find comparative fault, as we talked about before in the past, what comparative fault is, which means that you portion liability to certain different people, certain percentages. But coincidentally, I am working on one actually right now, and I was working on it this morning. My clients were driving down a road, no stop sign, no stoplight, a person with very little insurance, the minimum insurance policies. She pulls out, she T-bones my client, who spins out and hits a police car. Of all things. And the police car was sitting at the other end of the stop sign and knew not to pull out because of oncoming traffic. The police officer was hurt. My 2 clients were hurt. And in those kind of cases, the main driver, the female driver, she has 100% fault. Our clients didn't do anything wrong. The police officer didn't do anything wrong. But on cases like that, where you have multiple injured parties, going to the issue of damages, that's where it becomes an issue. So you have the police officer who's hurt, my 2 clients who are hurt, and how do we split that kind of money up and make sure everybody's not going to be made whole, but being made as whole as possible.
And can you talk about something that I can't remember if we talked about this before, but it's very, very important: the uninsured and underinsured motorist coverage. Every personal injury attorney talks about the importance of that. What is it, and why is it so imperative to have?
So uninsured motorist uninsured motorist is when somebody who hits you has no insurance. Underinsured motorist, which is really a lot more common, especially here in California, which is where somebody hits you, they have insurance, but they don't have enough to cover your damages.
Yeah, like you said before, like the minimum policy, right?
The minimum policy.
Yeah.
It used to be $15,000 here in California. Some people are still grandfathered into that policy. It's 15? Now $25,000.
15 is not very much.
It's been the same way, I think, since 1979 or so.
Wow.
I know that. So I'll have to research that. But it was late 70s is for sure when it was last updated to that. So what happens?
And the last time that was actually worth anything in an auto accident, probably.
Actually, I mean, you could, and in the 70s, you could buy a car for $6,000-$7,000. You can't buy a car for $15,000, a brand new car for $15,000 today. And injuries and this is more of the personal injury side, but it's even back in the 70s, an ER visit was a couple $100. Today it's $10,000 easy. I mean, I've seen huge ER bills.
Yeah, and health insurance doesn't cover it like it used to either.
Correct. So it's important to cover so what you do is you pay for the insurance yourself. So that way, in a situation where somebody who has a minimum insurance policy hits you, then your insurance will cover you and pay you for the pain and suffering that they don't have insurance for. And in the case I was talking about, yeah, we do have an underinsured motorist policy, and that's how, we'll try to work that out, especially with the police department. That's under work comp, workers' compensation, because he was on duty and working. So there's a lot of wheels involved in that one. But again, it's a minimum policy. So what do you do?
And we've talked before about, what to do after you get into an accident, of course, assuming, first check on your health and make sure you're okay. But the kind of evidence you need to gather, are there other factors in a multi-vehicle accident that people might not think of aside from the usual take pictures? Are there other things that you recommend?
Well, it would be basically the same thing, except instead of making sure you take pictures of the other car, make sure you take pictures of the other car as well. There's going to be more pictures, other cars with a plural. Yeah. But and typically multi-vehicle crashes have a bigger traffic scene, a rear ender. Right. I mean, it's, you're talking about maybe a 50-foot span, but with multiple vehicle crashes, I mean, you could be talking hundreds of yards, and that's not uncommon. So pretty much want to make everything the same, and always the same. The most important thing is don't admit fault. Don't say anything at the scene that may, because again, a lot of these times when you get into multi-vehicle crashes, somebody's looking for a percentage to put on anybody else just to try to get money, because a lot of times there's not a lot of insurance on the at-fault vehicle.
When it comes to insurance companies, how do they approach claims, multi-vehicle wreck car claims? It's got to impact the settlement process, I would imagine, given the more things involved, the more people involved.
It does, because they have to make sure they do their due diligence, make sure that they want to pay as little as possible. So if they can put a percentage on someone else or something else, then they're going to they're going to try and do that, which makes settlement a lot harder. So and then kind of getting back to the example earlier too, what'll happen with the insurance companies. So what happens on this case, and happens in typically in multi-vehicle cases with low policies, what the insurance company will do is just say, okay, we're going to pay the full extent of our policy. You guys figure out how much you want. And so we have to try to figure that out before, and then if that doesn't work, then they'll deposit that money with the court. And a lot of times you have to go to court and sue, and the insurance company is actually out of it because they're just admitting fault. It's all about damages at that point. Quite a few years ago, I had one. It was somebody, I forgot exactly how, but it involved a city bus. So there's about 20 people on this bus, and they only had a $30,000 policy. So that's where it can become a problem, is in cases like that, because and of course you try to put some fault on the bus, but if the bus driver they were stopped at a light and this person ran the red light and T-boned them while he stopped, it's kind of hard to put fault on the bus driver.
Yeah. Are there any sort of considerations, like city considerations or the company that runs the buses or something that to help those people out, or not really?
We try we try to find some type of violation of policy, some type of city code or something that's violated, but for sure. Yeah.
And you can't sue the insurance company for more money beyond policy limits, can you?
Well, that's probably a discussion for another day, but there are ways, but the damages would have to be so much, and you'd have to find somebody with assets to go after to avoid taking the policy limit.
So you're actually, when you file a lawsuit, you're suing the other driver, the at-fault driver?
Yeah, and that's a good point. Yeah, a lot of people don't realize. They think we're suing the insurance company. They think we're going after the insurance company. We're going after the defendant. We're going after the person who caused the injury, the person who breached their duty and caused injury to somebody else. Insurance is responsible for covering those damages, because most people don't have $15,000 in the bank. They don't have $30,000 in the bank, or $1 million, like some $1 million policies. They don't keep that in the bank. That's what the insurance company is for. So the insurance company is there to pay for the defendant. But the insurance company, you don't sue the insurance company, and your beef isn't with the insurance company. The beef with the insurance company comes because they don't want to pay out, because that's their business.
Yeah, because that doesn't help them.
And a lot of times, the defense attorneys will say, hey, this defendant wants to get this done, but the company, they don't have it valued at whatever the insurance company is. So yeah, so you and when you file a lawsuit, it's your name versus the defendant.
Yeah, I've seen them before. Yeah.
Yeah,
Yeah.
so you
Yeah.
don't, and actually in California, you can't even mention you can't, the best way to talk yourself into a mistrial is say the word insurance. You can't bring it up. You can't say it. If you use it in your closing arguments, it'll get thrown out.
Wow.
It is not, you cannot bring up the fact that their insurance or their limits or anything like that, because that's the quickest way to get yourself to a mistrial.
Wow. Interesting. Interesting. So when multiple parties are involved, does it make your job harder to like figure out what's going on, to negotiate with various insurance companies? Because obviously you're trying to get fair compensation for your client, but are these more complicated cases?
Yes, sometimes no. It just depends. Like we said, if it's a minimal policy and they're just arguing over damages, those can be frustrating, because obviously we want to try and get as much for our client. But you do have to, there is equity. We have an equitable court in the sense that, if somebody breaks their neck over here and somebody has back and neck pain over here, who's going to get more money in a court of equity? Somebody dies over here and somebody has a headache over here, who's going to get more compensation, right? So those can be tasking, but the ones with disputed liability, those can become interesting, because if vehicle one started it, but then vehicle two maybe did something, or vehicle three also breached some type of law, like not fully stopping at a stop sign or doing something, then you can try to find. But usually the first car is going to be the most at fault, because they're the ones who said, the proximate cause. That's what we call in the legal system, the proximate cause and the actual cause. They're the ones who start it. They're the ones who are going to probably, most of the time, unless I can think of a scenario, are going to take the brunt of the comparative at fault.
And how does that comparative at fault work again? I know we've talked about it in the past.
It's where you just apportion percentage,
Okay.
and if it goes to trial, it's the jury who decides what percentage of fault. So 50%, 75%, 50% here, 50-50, 75-25, 90-10, whatever numbers the juries decide to come to. That's what comparative fault is. And like I said, typically the first car who puts the chain of events into action is typically going to bear the brunt, but I'd have to think a little bit more of how a second vehicle could get more.
Mhm.
I mean, I'm sure it's possible.
If there are more than one, if there's more liability than just on one car, does that, like how does that change the amount of money that the insurance company is willing to give out? Are they only willing to give out a certain amount based on how at fault their client is?
Yeah. So if a jury comes back at 75% fault and the damages are $100,000, you're on the hook for 75,000.
Okay. So
Yeah.
just simple math.
Simple math. Yeah.
Okay.
Lawyer math.
Lawyer math.
Yeah.
Do you have any stories aside from the one you just told about the one with the cop, where like a success story where you had a multi-vehicle accident and you were able to kind of get a favorable outcome for your client?
Quite a few. Obviously the big ones are the ones with big policies.
Mm-hmm.
We've had a case where one truck crashes and then another truck comes along and hits that vehicle that's on the side of the road. That one we were able to resolve before trial, because they kind of came to the agreement of 50-50. But again, it's kind of tough to put more liability on the second vehicle than the first. A lot of time I've had one with it was a good one. It was a decent case. One car makes a left turn in front of somebody else, and the problem is that he doesn't hit anybody, which causes the car going straight to swerve into the other lane and hit somebody else head on.
Oh, interesting.
That's what we
Yeah.
call it's a non-contact traffic collision. The
Okay.
vehicle at fault is the one who made a left-hand turn, but also you can't. And obviously that one was tough, because the second vehicle, what we called vehicle two, he's trying to avoid a crash. Well, is it prudent to go into the opposite lane of traffic on a 2-lane road when you could have gone right or done something else?
Yeah, that's tough though in the heat of the moment, right? You freaked out when you see this car coming and you're just like, ah.
That was another one. But we ended up, our clients ended up getting the policy limits on that one too. That took a while.
Mm-hmm. Yeah, that's a complicated one. I never thought of that, but
and I think that's one thing to consider, probably, if you're going to take out of this entire conversation, is that when you do have situations like that, cases like that, whether it be two cars, the car crashing, the car that spins out and hits a parked car or hits a stopped car, they do take a lot longer. They do a lot of time require a lawsuit. They're hard to resolve prior to filing a lawsuit, because there's no set law, there's no set rule of comparative negligence.
Mm-hmm.
It's what is a jury going to ultimately say. So you kind of have to exchange discovery. You kind of have to go through the depositions to figure out what we think a jury's probably going to come to.
Yeah, that makes sense. All right. Well, thanks for tuning in to the Moody Lawyer with attorney Josh Moody. To connect with Josh, visit moodylawyer.com. And don't forget to like and subscribe to our channel. Josh, thanks so much for your time. Very interesting topic. Really appreciate all the insight.
Thanks for having me. See you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.